Powers and duties of a police officer on the receipt of FIR. Section 154, Section 175 CRPC. Information. Information relating to cognizable offence may be given by any person to the police officer. It may be oral or in writing. If it is oral, it is reduced to writing, read over to the informant, signed by him. The substance of it is entered in the police diary. If the information is in writing, it is signed by the informant and the substance is entered in the police diary. This information is FIR. Copy of FIR shall be given free of cost to the informant. If the information is in respect of a non-cognizable offence, the police officer cannot directly investigate. He refers to the magistrate. If the magistrate orders, then only the sub-inspector may investigate. If the officer refuses to record in cognizable offence, the informant may by post send the substance of the information to the SP concerned, who may direct investigation in suitable cases. Spot investigation. The police officer informs the magistrate and proceeds to the spot for the investigation and for collecting the facts and circumstances of the case. He also takes steps to arrest the accused. On arriving, he calls a few respectable persons of the locality and in their presence he conducts the mahazar. These persons are Panchnamas witnesses. He then draws up a report and which is signed by the Panchnamas. In case of a murder, he examines the bruises, wounds, etc. Weapons, if any, are seized and sealed. Blood-stained clothes and other things found are sealed as exhibits. The dead body is then sent to the post-mortem. This is called the mahazar report. The police officer may require the attendance of persons acquainted with the circumstances of the case. Male below 15 and a female of any age may not be called to the police station. He examines them orally. The statements made during the investigation may be reduced to writing. They need not to be signed. He should not use force or induce them. Such a statement may not be used in a trial. He is empowered to search. Section 165. The accused may be arrested without a warrant in cognizable cases. He must be produced before the magistrate within 24 hours of the arrest. He may be kept in the custody under the order of the magistrate. Remand. The maximum period for remand is 15 days, but according to the new act, this may be extended if the magistrate is satisfied that there are adequate grounds. The maximum period of detention shall be 60 days. Thereafter, he shall be released on bail. Remand should be made only after the accused is produced before the magistrate. The magistrate shall record the reasons for remanding. Police diary. Police officers should maintain a diary and a record of the time of the reception of FIR, the time of beginning and closing of investigation, places visited, a statement of circumstances. The criminal courts may call for the diary. The accused cannot call on it except when it is used by the police officers to refresh his memory. The police officer submits a final report to the magistrate setting forth the name of the parties, the nature of the information, the accused, whether he is in custody or not, post-mortem report, etc. With the final report, the investigation comes to an end.